All right, today we're diving into a massive case that's happening right now at the Supreme Court of Canada. And really, it's a classic digital age showdown, right? You've got a tech giant on one side and the government's privacy watchdog on the other. And believe me, the decision here could fundamentally change how your personal information is protected online.
So what's at the heart of all this? Well, it's a massive data disclosure. We're talking about the personal information of over 600,000 Canadians. Facebook's own estimate is that this much data was potentially shared with a third-party app, all without people's direct knowledge or, their consent. That is a truly staggering number.
But here's the real twist, the part that's kind of hard to wrap your head around. That massive number, over 500,000 people, all started with just 272 Canadians. That's it. Just 272 people installed a single app, and that action just spiraled into a potential data breach that affected hundreds and hundreds of thousands.
So how on earth did that happen? I mean, how could so few actions have such a gigantic ripple effect? Well, it's kind of like a digital detective story, and in this explainer, we're going to break down exactly how it all went down.
Okay, so Section 1. Let's start unwrapping this massive digital puzzle.
Okay, now for Section 2. And to really get what happened here, you first need to meet the cast of characters.
So you've got four main players here. First, obviously, there's Facebook Inc., the platform where this whole thing happened. Then you have the Privacy Commissioner of Canada. They're basically the government watchdog whose job it is to protect our personal info. Then we've got Dr. Alexander Kogan. He's the professor who actually created the app. And finally, there's Cambridge Analytica, the company that bought all the data he collected.
And the whole thing, this entire controversy, it all started with this one app. It was called This Is Your Digital Life. And on the surface, it just looked like a fun, harmless personality quiz. But behind the scenes, it was doing something way, way more powerful. So, Section 3. How exactly did a simple quiz app manage to collect so much data? Let's get into the mechanics of how this digital door was basically just thrown wide open. Okay, so here's how it worked. It was a three-step process. Step 1. A user in Canada installs the This Is Your Digital Life app. Pretty simple. Step 2. The app asks for permission to get their profile data. Again, seems normal. But Step 3. Step 3 is the crucial one. The app didn't just collect data from the user, it also collected data from their entire list of Facebook friends. Think about that. It's like you give a developer a key to your apartment, but you don't realize that same key also unlocks every single one of your neighbor's doors. That's the scale we're talking about. And this really highlights the huge gap between what people thought was happening and what was actually happening. A user thinks, okay, I'm just sharing my quiz results, maybe some basic profile stuff. But in reality, the app was scooping up their profile info, their friends list, and the profile info of all of those friends. We're talking about people who never even heard of the app, let alone gave it permission to do anything.
And here's a really important point. This wasn't some kind of bug or a hack. It was actually a built-in feature of Facebook's old developer platform. It was called Graph API version 1. And it was literally designed to allow this kind of broad access to friend data. That's what powered a lot of the early social features on the platform.
Now, crucially, Facebook knew this was a problem. By 2014, they were already rolling out a new, much more secure system that shut down this kind of friend data access. But, and this is a big but, they gave existing apps, like Dr. Kogan's, a 1-year grace period to get with the new program. And it was during that grace period that a lot of this data collection was still happening on the old, leaky system.
So Section 4. How does a technical feature from an old API turn into a decade-long legal battle that goes all the way to the Supreme Court? Well, let's trace that journey. So look at this timeline. The app launches way back in 2013. By 2015, reports are already coming out that the data was sold to Cambridge Analytica. It's not until 2019, though, that the Privacy Commissioner in Canada launches a formal complaint. The case bounces through the courts. First, the federal court dismisses the commissioner's application, but then the federal court of appeal overturns that, siding with the commissioner. And that's how we get to today, with the final appeal being heard at the Supreme Court of Canada. And listen, this is not just a fight between Facebook and the government. You have all these other groups jumping in, what are called interveners. We're talking civil liberties groups, consumer advocates, privacy experts. When you see this many different organizations getting involved in a case, you know the stakes are incredibly high. The outcome is going to affect, well, pretty much everyone. Which brings us to Section 5, the absolute core of this case.
When you strip everything else away, it all boils down to one fundamental question. Who is actually responsible for protecting your data online?
The entire legal argument here hinges on a Canadian federal law called PIPEDA. You can think of it as the official rulebook for how private companies are supposed to collect, use, and share our personal information. And now, the Supreme Court is being asked to figure out what those rules actually mean when you apply them to a giant global social media platform. So here is the first major legal question that the court has to answer. This is taken right from the case summary. Did Facebook fail to get meaningful consent to disclose personal information? I mean, did people really, truly understand that by installing one little quiz app, they were also giving consent for all their friends' data to be shared too?
And then there's the second, equally important question. Did Facebook fail to maintain adequate security safeguards to protect that information? In other words, does letting an app developer suck up all that friend data through an old system count as a failure of security? At its core, it's asking, is the platform responsible for what other companies do with the data it lets them access? So let's just recap why this case is such a big deal. First, it shows us how one tiny action can have these massive, exponential consequences online. Second, it's forcing our legal system to define what meaningful consent really means in the digital age. It's also putting a platform's responsibility for all the third-party apps on its system right under the microscope. Make no mistake, whatever the court decides here is going to have a major impact on the future of digital privacy for all of us in Canada.
And all of this really leaves us with one final big question to think about. I mean, sure, this case is about Facebook, but the implications go way beyond that. It makes you think, doesn't it? The next time you download an app or you sign up for something and you see that little checkbox, it's worth taking a second to ask yourself, when I click agree, what am I really agreeing to?